Welcome to the McNeese Privacy and Data Security podcast series. This podcast will address cybersecurity by Devin Chwostek, attorney at law. Mr. Chwostek is chair of the Privacy and Data Security Group and practices in the litigation and public sector groups at McNeese.
Thank you for joining me today for this podcast where we're discussing data breach notifications. Most of us have received a letter in the mail because a merchant that we've shopped at or some other business has suffered a breach of their data security, requiring them to notify us that our personally identifiable information has been accessed by third parties. Those notifications are sent pursuant to the data breach notification laws of various states. What is a data breach? A data breach is any exposure of unencrypted personally identifiable information to unauthorized third parties. This can result from hackers intruding upon your system to steal valuable information electronically, or it could result from the physical theft or loss of information. That might include an unencrypted thumb drive being disposed of or misplaced by an employee, or even a box of records that falls off the back of a truck or is misplaced by movers. If your company suffers a data breach, your first priority should be to make sure that the breach has been secured. Once you've determined that your system is secure, the second goal is determine what types of records have been taken or lost, and assess your legal liability to notify consumers, employees, regulators, and law enforcement of the breach. Determining what types of data breach notifications will be required will take experienced legal help. 47 states plus the District of Columbia have individual breach of personal information notification laws. Each state's laws protects the residents of that state, which means a Pennsylvania company that does business nationwide will have to comply with the laws of each state if the information of residents of those states has been implicated in the data breach. So what is personally identifiable information? Generally, the laws describe personally identifiable information as an individual's first and last name combined with either their social security number, driver's license number, or financial account information, including bank account numbers and credit and debit card information. Some states, however, have broader definitions of personally identifiable information, which might encompass items like birth dates, mother's maiden names, and other passwords or other individualized information. In Europe, the data rules are even broader and require notice whenever any information that could be tied to a user is taken. That could include health information or any information that might reveal a person's racial or ethnic origin, political affiliation, or even just the IP address of the computer they use to access an electronic system. Some states require notifications only when the facts indicate that the breach will likely cause loss or injury to consumers. But at least a dozen states require notifications regardless of whether the breach is likely to lead to any harm to the persons whose records were included. About half of states require that notices be provided not just to the individuals affected, but also to the state attorney general's office or other law enforcement agencies, and perhaps also to credit reporting agencies. If your company suffers a data breach and fails to promptly provide notification to the affected individuals, your company could suffer significant legal penalties. Those could include fines and civil regulatory actions from state attorney general's offices. Accordingly, if you suffer a data breach, you should reach out to experienced legal counsel to guide you through the notification process. If you have questions about this or any other data privacy issues, please contact us using the information on your screen.